Hello everyone and welcome to our webinar today. This is our regular annual employment law updater session looking back and forward at some of the recent and upcoming employment law developments in the UK. My name is Chris Fisher. I'm a partner in the Employment and Benefits team at Mayor Brown, and I'm joined today by my colleagues Miriam Bruce and Francesca Ingham. Now most webinars at the moment are understandably focusing on one particular topic, and it's not Brexit. But we've decided to make this a COVID-free session, or as much as we possibly can do. So my apologies if you've tuned in for the latest COVID updates. You'll be disappointed, but fear not, as we are currently running a series of COVID return to work webinars, the first of which ran last week, and we'll be sending details of those as well when we circulate the recording of this session and the materials from it. So our agenda for today, we're going to look at firstly some recent legislation changes and then some case law, and we're going to cover some recent cases on restrictive covenants in employment contracts, unfair dismissal, TUPE and data privacy, and then at the far end we're going to have a quick look at some of the forthcoming changes in cases that we're expecting to come through and legislation that we're looking out for over the next 12 months. So without further ado, to kick things off, I'm going to hand over to Miriam for a look at some recent legislation changes.
Thanks, Chris. When we first started planning this seminar a few months ago, I'd expected to be talking about IR35 or the off-payroll rules, but that will be coming up later when Chris looks forward to what's coming up on the horizon. First up instead, in terms of legislative changes in the last 12 months, is changes to Section 1 statements, i.e. the written statement of basic terms of employment required to be given under Section 1 of the Employment Rights Act. As you'll know, most employers comply with this obligation by providing the relevant details in an employment contract. However, significant changes in respect of Section 1 came into effect for any person starting work on or after the 6th of April 2020. First, and most significantly, the right now extends to workers, not just employees, and that is a change from what it was before. Secondly, current employees who were employed prior to the 6th of April this year can request a newly compliant statement, and this has to be provided within 1 month of the request. In terms of other changes, some additional particulars have now been added, including providing details of benefits and paid leave, and that's not just looking at holiday, that's also referring to family leave, for example. In addition, details of training have to be provided, including whether that training is paid for by the employer or the worker, and whether it's mandatory or optional, and the days of the week a worker is required to work, if those working hours and days may vary, and how the variation will be determined. It's worth pointing out that the provision of the majority of written particulars will now be a day one right. There is no longer a service requirement for provision of Section 1. The majority of written particulars therefore need to be presented to the employee or worker as a single document on or before the date on which employment or engagement begins. However, it's still the case that certain of the required information can be provided in an additional reasonably accessible document. For example, details of paid leave may be in an employee handbook. However, the principal statement has to contain some sort of reference to this additional document. Finally, some information can be provided at a later date, as long as that is no later than 2 months from the start of employment, and this includes details, for example, about pension arrangements. In terms of practical points, we think it's worth reviewing, if you haven't already done so, your employment contracts to make sure that they include the new Section 1 items, and importantly also review what information you're providing to workers to make sure that you are complying with the Section 1 requirements in respect of that category of staff. The second legislative change I wanted to mention is the introduction of parental bereavement leave, also enforced from the 6th of April 2020. This is a form of leave which you may remember has been under discussion for many years now, and it's now finally been introduced via a private member's bill. Now, it is only available to employees following the death of a child under 18 or stillbirth after 24 weeks. There's no minimum length of service requirement. And the right applies to the child's parents, which includes adoptive parents, prospective adopters, intended parent under a surrogacy arrangement, a parent in fact, that's someone who looks after the child in that person's own home for the previous 4 weeks, or that person's partners, but it doesn't include paid carers. And the statutory right is actually very, very limited. It's limited to 2 weeks, which can be taken as 2 continuous weeks or 2 separate weeks, and it may be used in the first 56 weeks after death. In terms of statutory parental bereavement pay, this is also something that's been introduced. It's only available to employees with at least 26 weeks continuous service, and it's paid at the same rate as statutory paternity pay or shared parental pay. And again, it's fairly limited. It's the maximum of 2 weeks as per the leave. Now, of course, many employers in this situation will be providing a more generous entitlement, but we just wanted to flag this type of leave coming in, as it's been one that we've talked about as a potential new piece of legislation over the years. So that is now finally in force. Before I hand over to Chris to discuss some contract and restrictive covenant case highlights, I just wanted to mention some other important legislative developments in the last 12 months. In fact, as with Section 1 and bereavement leave, all of these changes on this slide are also effective from April this year. So, first of all, as you'd expect, April sees the national minimum wage increase, as well as various statutory rates, including a week's pay for statutory redundancy pay purposes and the rates for family leave and statutory sick pay. In addition, for dismissals that take effect on or after the 6th of April 2020, the maximum compensatory award increased to 88,519, up from 86,444. The maximum compensatory award will, of course, remain the lesser of a year's pay, or the newly increased 88,519. Secondly, there's been a recent change impacting agency workers, namely that with effect from the 6th of April 2020, the so-called Swedish derogation has been abolished. You may remember that the Swedish derogation gave employers the ability to pay agency workers less than their own workers in certain circumstances. Under the derogation, agency workers could exchange their right to be paid the same as directly recruited employees for a contract guaranteeing pay between assignments. However, the government's Good Work Plan, published at the end of 2018, highlighted the misuse of the derogation by some end users, hence its abolition in order to stop agency workers losing out on their equal pay rights under the agency workers regulations. And finally, for dismissals on or after the 6th of April 2020, employers' national insurance contributions will be imposed on termination payments which are in excess of the £30,000 tax-free exemption. Up until that point, termination payments above £30,000 were free of employers' national insurance. However, termination payments, as opposed to notice pay, will remain exempt from employee national insurance contribution without limit post-April 2020. So that change obviously will increase the cost of severance payments for employers. I'm now going to hand over to Chris, who's going to talk about some contract and covenant cases of the last 12 months.
Thanks, Miriam. So employment contracts now, and specifically I wanted to look at a couple of cases on restrictive covenants, both of which are very recent cases. The first one is about a non-compete clause and the interaction of it with the garden leave clause, and it's called Square Global and Leonard. So the question in this case, or at least the question that's of interest, is does a non-compete clause in a contract have to be drafted so that it says that it is reduced by any period of time that an employee spends on garden leave? And many of you will know a lot of contracts do say this. Non-compete clauses are drafted in this way, and that's because of quite an old case now, a 1996 case called Credit Suisse and Armstrong, where the Court of Appeal said that if a non-compete clause didn't have that garden leave offset provision, it might affect the enforceability of the non-compete clause, and so a court might be more willing to strike it down as unreasonable if it wasn't drafted that way. Now, these comments in the Credit Suisse case were only obiter comments. They weren't part of the actual decision, but despite that, it has become a fairly common practice since that case to see garden leave and non-compete clauses drafted in that way so that they offset against each other. So in Square Global, the facts were that Mr. Leonard was an interdealer broker, and his contract had a 6-month notice period and a 6-month non-compete. It also had a garden leave clause, but that garden leave didn't offset against the non-compete period. It wasn't drafted that way. So Mr. Leonard resigned to join a competitor, and he argued when he resigned that he'd been constructively dismissed, and so he said that he was free immediately to go and join the new firm without any period of notice and without any restrictive covenants at all. Now, the High Court judge in this case rejected the constructive dismissal claim. He found that it was a contrived attempt to release himself from his contract, and so he granted an injunction for 6 months, stopping Mr. Leonard from joining the competitor to reflect the notice period. And then the question was, would he grant another 6 months to reflect the non-compete clause? Now, Mr. Leonard's counsel argued that the 6 months notice period injunction should be enough, and in any event, the non-compete clause was unenforceable because it didn't have a garden leave offset provision in it. And the judge disagreed with that. He said, no, I'm going to grant a non-compete injunction for a full 6 months on top of the injunction I've granted for the notice period. So he granted an injunction for 12 months in total. He said the fact that the non-compete didn't have a garden leave offset didn't make the clause unreasonable or unenforceable. He said it was true that the court could take any period of garden leave into account when it decides how long to grant a non-compete injunction. But here, he decided it wasn't necessary to reduce it and it was appropriate to grant the full 12 months of protection. So, is our advice then that you no longer need to worry about drafting non-compete clauses with a garden leave offset? In short, no, it's not. We think it's still better to include a garden leave offset provision, particularly where you've got notice periods and covenants of any length to them. And we'd say 6 months or 12 months is certainly long enough. So we're not changing our advice on this, but this is a helpful case, albeit it's only a High Court case. It's not binding on future High Court judges, but it's the second time the High Court has given this indication that the lack of a garden leave offset is not fatal to a non-compete clause. Okay, so my second employment contract case, which is also a restrictive covenant case, again very recent. This time it's a Court of Appeal decision, and it's called Allen versus Dodd, and this one is all about inducing breach of contract. And the issue in the case is when a new employer can be liable for inducing a breach by an employee that it recruits from a competitor, where that employee breaches one of the covenants they owe to their previous employer. When can the new employer be liable on an inducement basis for that breach? Now, the facts in Allen and Dodd were Mr. Pollock worked for David Allen, which was an accountancy firm, and his contract contained a 12-month covenant restricting him from soliciting or dealing with clients, quite a common client restriction. He left David Allen to join Dodd, which is a competitor accountancy firm. Now, Dodd realized that Mr. Pollock had these covenants, and it took advice from its solicitors as to whether or not they were enforceable. And the solicitor's advice was that it was more likely than not that they were unenforceable. And the reason for that was the solicitors came to the view that they were just too long. 12 months was too long for client covenants of that nature. And so they said they were more likely than not, or probably, unenforceable. Litigation ensued because Mr. Pollock duly went ahead and acted against his covenants, and so he was sued for breach, and the finding of the court was that the covenants were enforceable. The period was not too long, and so there was a breach by Mr. Pollock. So the question then became, in the claim against Dodd, is whether or not Dodd could be liable for inducing Mr. Pollock to breach his covenants by allowing him to work in the way that they did. And the Court of Appeal said no, Dodd wasn't liable for inducement based on these facts. And they said that a key part of the test for inducing breach of contract is that the new employer must know that they are inducing a breach. So if they've taken legal advice, and that legal advice is that the covenants are probably not enforceable, or on the balance of probabilities they're not enforceable, then that will be enough for them to avoid liability for inducing breach. But if the advice had been that it was arguable, then that might not be enough. They might still be liable for an inducement claim on that basis. It all depends on how unequivocal the legal advice is that the client receives. So, but the key point is it didn't matter in this case that the advice had turned out to be wrong. It was reasonable of Dodd to rely on it. So our advice to clients in this situation is always ask a new recruit whether they have covenants and about what do those covenants provide. If you are looking to avoid those covenants or act so that they don't apply, then take legal advice on the enforceability of the covenants. If the advice is that it's more probable than not that they are unenforceable, then you should be free from the risk of an inducement claim. However, if the advice is more equivocal than that, and it's simply that, well, it's arguable that they may be enforceable, then that may well still leave you open to an inducing breach of contract claim. And obviously, bear in mind that we're only talking about inducement claims here. The underlying claim against the employee would just depend on whether or not the covenant is enforceable. And if, as often is the case, a new employer is standing behind their new recruit and possibly indemnifying them, then it won't really matter whether you're also liable on an inducement claim, because you're going to be liable for any damage that flows from the employee's initial breach of contract. So that's Allen and Dodd, and now I'll hand over to Fran, who's going to give us an update on a very interesting recent unfair dismissal case.
Thanks, Chris. So moving on now to an unfair dismissal case from last year, which has some useful practical pointers to bear in mind when issuing dismissal letters. This case is a Court of Appeal decision on a preliminary issue as to whether the time limit for accepting an ET1 should be extended. The facts of the case are that following disciplinary proceedings, the employer dismissed Mr. Brophy, who was severely dyslexic, with immediate effect for gross misconduct. He was informed of the decision on the telephone, and this was followed up in writing a week later. The letter, which came by post, stated, "Further to the disciplinary hearing held on Wednesday the 21st of June 2017 and our telephone conversation on Thursday the 29th of June 2017, I'm writing to inform you of my decision." It went on to say, "I have no further option but to dismiss you for gross misconduct. This dismissal will be with immediate effect from the 29th of June 2017. The letter did not make clear it was confirming what he'd already been told, nor did it reference why the dismissal was effective from the 29th of June, in other words, the date of the call. Mr. Brophy told his brother of the dismissal, who misread the letter, and understood that the dismissal took effect on the date of the letter. He therefore presented the ET1 on that basis, which was out of time. The Employment Tribunal granted the extension of time on the basis that the individual was a vulnerable person who had dyslexia, and that the letter was unclear and contradictory. The Court of Appeal upheld this decision and held that it was reasonable for Mr. Brophy and his brother to take the views that his formal dismissal took effect when he received the letter. The claimant's severe dyslexia was clearly a factor in the decision reached, but our view is that this case is of general practical importance as it emphasises some practical takeaway points. First, the importance of ensuring that dismissal letters are clear and that there is no ambiguity about the effective date of the dismissal. Secondly, if the decision is being notified verbally, then the letter should make clear that it is sent as a confirmation of the decision and not a notification. It's also advisable that any letter is sent to individuals as soon as possible after the verbal notification, and preferably the same day to avoid any confusion. This case therefore provides some practical pointers going forward when it comes to drafting dismissal letters. I'll now hand over to Chris, who will talk around cases relating to 2P from last year.
Thanks, Fran. So I'm going to talk now about 2P, a couple of 2P cases, and they are very recent cases from this year, and they are both very interesting and we think quite important. The first one is a recent European Court of Justice decision called ISS and Govert, and it's a case involving the Belgian form of 2P, which essentially is the same, or largely the same as the UK version in terms of transfers of undertakings, and so the ECJ decision from this case would apply equally to a UK 2P case. Now the question in ISS was what happens when you have an employee who's working in a business or on a contract that transfers to more than one buyer or new service provider. So transfer to more than one transferee. The facts in ISS were that ISS had a cleaning contract with the city of Ghent in Belgium, and it covered 3 categories of buildings, and they were labelled lots. You had lots 1, 2, and 3. And Ms. Govert was the project manager for all 3 lots. So she spent a portion of her time and effort across each of the 3 lots. Now, Ghent, the city of Ghent recontracted, retendered for the contract. ISS was unsuccessful, and the contract went to 2 new providers. So 2 of the lots went to one new provider called Italian, and 1 lot went to a second service provider called Cleaning Masters. Now, Italian, the first successful transferee, took lots which Ms. Govert worked mainly on. So she worked 85% of her time on the lots that went to Italian, and the remaining 15% of her time she worked was on the other lot, the 3rd lot that went to Cleaning Masters. So the question for the Belgian courts, which they referred up to the European Court of Justice, was did Ms. Govert's transfer solely to Italian because she spent the large majority of her time working on the lots they took, or was her employment split between Italian and Cleaning Masters in a sort of 85-15% way? And I think I was surprised with the outcome, as I think a lot of employment lawyers will have been, certainly from what the UK case law would have probably predicted, because the European Court said that Ms. Govert's transferred to both transferees, 85% to Italian and 15% to Cleaning Masters. So they did acknowledge that there were practical issues with this outcome that they had come up with, and they said that if this was impossible, which they said was a question for domestic law of the country concerned, or if it would result in the employee's terms and conditions becoming worse, then the contract could be terminated, and that might be by the employer or the employee. may call for the employment to be contracted on that basis, but the liability would transfer to the transferee employer, they said, in proportion to the allocation of time or effort across the respective businesses that were going across. So we think this has got important implications, this case. There hasn't been a lot of publicity about this case, which is surprising, given how significant it could be. But it's certainly relevant to business sales, it's relevant to outsourcings, and it's not just transfers to multiple transferees, but it seems to me that the logic would apply equally to an employee who's working partly in a business or on a contract, part of which is being retained and part of which is transferring to a new employer. And so for buyers and service providers taking on contracts, the immediate question, I think, is check your indemnity clauses, check that they cover off the possibility of inheriting part of an employee or part of an employee's employment contract, and bearing in mind that that could be a very small part. I don't think, if the logic of this case is right, the risk is not just in employees who work a majority or all of their time on the business or the contract that's transferring. That little stub bit of their employment would also transfer somewhere if this case is to be followed, and so that risk needs to be covered off. So that's ISS and Govert. The second TUPE case I'm going to come on to now is a case closer to home. That's an EAT case. And this is the case of Ferguson and Australia Asset Management, which is a case all about the provision in our domestic UK TUPE law that prevents changes to employees' contracts of employment where the reason for those changes is the TUPE transfer. And so obviously this is intended to protect employees from adverse changes when a TUPE transfer happens, so that they transfer across on the same favourable terms that they're currently on. But what about positive changes? It was never clear whether or not this prohibition also prevented positive changes. And the thinking was that it wouldn't do, that positive changes would be enforceable by an employee. And that is what the government guidance said on the TUPE provisions when they were amended in 2006, and this provision was brought in. So the facts in Ferguson and Australia were there were 4 directors of a property management company that managed the Berkeley estate in London. The owners of the estate terminated the contract and moved it to a new management company, which was Australia. Now, the directors of the original management company weren't too pleased about losing the contract to a competitor, and so they decided that it was time to update their employment contracts before the TUPE transfer happened. And this update included, what's fair to say, some fairly generous changes. They gave themselves a guaranteed bonus of 50% of salary, a 15% salary increase, and a severance clause that would pay them 1 month pay for every year of service. So this is what's known as a poison pill case, really. They'd made these positive changes knowing that their competitor was about to inherit them under TUPE. Now, as I say, Regulation 4 of TUPE says that variations are void if the reason for them, or the principal reason for them, is the transfer. And so Australia argued, in this case, that they weren't bound by these changes because they were void under TUPE, and it didn't matter that they were agreed with the employer at the time, the management company that employed the 4 directors. They were void. So the court had to look at this question, and it agreed with Australia. It said, yes, that's correct. This provision in TUPE doesn't just apply to negative changes, it applies to positive changes as well. If they are made because of the transfer, and they are void and they are unenforceable. Now you can see that this appears to be the right decision in a case like this, in a poison pill case such as this, but I think such cases are hopefully relatively rare, but there will be many times where I think a transferor employer will make changes to employee contracts prior to a TUPE transfer along similar lines. It might agree retention bonuses so that key employees don't leave ahead of a TUPE transfer. Now, are those by reason of the transfer? So does that mean that they're unenforceable and that the employer could refuse to pay out under a retention bonus such as that? Well, the court acknowledged that these sorts of cases would come up, and they said, well, not necessarily, because there were two reasons why an employee might be able to enforce a positive change in those circumstances. And they said one might be a estoppel, which is the doctrine where if an employee has relied to their detriment on a promise by an employer, then the employer will be stopped from going back on it. So that's one possibility. But the other one, which I think is where a lot of these cases are now going to focus, is where the reason for the change that's been made is not, strictly speaking, the transfer, or at least the transfer is not the sole or principal reason for the change. Now, it might be connected to the transfer, but there may be some other commercial justification for making a positive change. For example, in the example I gave, where retention arrangements are introduced to retain key employees ahead of a possible sale or a recontracting in order to protect the business, not just because of the specific TUPE transfer that's about to happen. So I think our advice would be, where you are making positive changes that you want to ensure remain enforceable around a TUPE transfer, and there are commercial reasons for making them which are not just the transfer itself, it is worth spending some time thinking about expressing that in the contractual documentation surrounding the variations, so that that can be pointed to later on if and when the changes are challenged, and so that you can separate them from the TUPE transfer itself. That's the case of Ferguson and Australia, and that's the end of my TUPE section. I'll hand over now to Miriam to talk about some recent privacy cases.
Thanks, Chris. So moving on to privacy cases now. Post-GDPR, privacy cases have certainly been in the spotlight for employers, and so I'm going to focus on two of the most important of those cases in the last 12 months. First up, the Morrisons case, in which the supermarket successfully argued in the Supreme Court that it could not be held vicariously liable for a data breach in which the personal details of employees and former employees were exposed by a rogue employee. The facts of this case were that a senior internal auditor at Morrisons leaked a file containing personnel details of thousands of employees and ex-employees to a file-sharing website. He'd made a copy of the relevant file after becoming disaffected following a minor misconduct issue. As a result of his actions, more than 9,000 Morrisons employees and former employees brought a claim for compensation against the supermarket for breaches of the Data Protection Act, misuse of private information, and/or breaches of confidence. Their argument was that they had entrusted their information to their employer, who had failed to keep it safe, and that if the supermarket wasn't personally liable for the breach, then it should be held vicariously liable for the rogue employee's actions. Now, the case made it all the way to the Supreme Court, which overturned the decisions of the lower courts and confirmed that to determine vicarious liability, the court had to consider two issues. First, were the actions in question within the acts the employee was authorised to do? And secondly, were the wrongful conduct and the acts the employee was authorised to do so closely connected that the wrongful conduct may fairly and properly be regarded as done whilst acting in the ordinary course of the employee's employment? The court also stated, and this is the key point really, that in determining whether there is a sufficiently close connection, it's important to draw a distinction between cases where the employee was engaged, however misguidedly, in furthering his employer's business, and cases where the employee was engaged in solely pursuing his own interests, as was the case here. So applying that clarified test for vicarious liability to the facts of this case, the Supreme Court held that first, the senior auditor's task was to collate and transmit payroll data to the external auditor. The publication of the data on a third-party website did not fall within the actions he was authorised to do. And secondly, whilst the task allocated to the auditor enabled him to publish the personal data in question, that publication was a personal vendetta. It didn't further his employer's business at all. In fact, it was designed to do the complete opposite. It was designed to damage Morrisons as much as possible. As a result, the Supreme Court held that Morrisons was not vicariously liable for the individual's wrongdoing. And looking at this case, it's obviously been working its way through the courts over the years, but the final Supreme Court decision is an important and helpful decision for employers because it helps to clarify the previous misunderstandings regarding the test for vicarious liability that had come up through the prior decisions. And additionally, from a privacy perspective, at a time when the profile of and sanctions for breach of a party's data obligations has increased dramatically, the decision also reduces the risk that employers could face a potential double jeopardy when a data breach arises from the actions of a rogue employee, despite implementing appropriate technical and organisational measures to ensure appropriate data security. Usually what happens when there's a data breach of this nature is that the employer or the company has to spend significant amounts of money to assist those persons who've suffered from the data breach, and that's exactly what happened to Morrisons in this case. It would be seemingly very unfair if the company was also found at risk of also found to be vicariously liable to those same people for the actions of the rogue employee that gave rise to the data breach. So an important and helpful Supreme Court decision. That's the case of Morrisons and others. And I'm now going to move on to talk about my next privacy case. So moving on to my second privacy case, this is the case of Phoenix House and Stockman. And this is a really interesting EAT case which considers the position where an employee covertly records a meeting with the employer and then tries to use that recording in a complaint against the employer at a later date. So the factual scenario here was that there had been a job restructure within Phoenix House and there were problems around finding an alternative position for Mrs. Stockman. She eventually moved into a more junior role, but working relationships were strained. As a result, she was summoned to a meeting to discuss and decided to covertly record that meeting with HR. She didn't say anything at the time or indeed immediately afterwards about the recording. There was a grievance and a formal process, and at the end of the formal process she was dismissed, and it came to light during her subsequent tribunal claim that she had made this covert recording. In reaching its decision, the tribunal found that her dismissal had been unfair and there had also been a breach of the whistleblowing legislation. And where it becomes relevant for us is that the employer appealed and challenged the way in which the tribunal had dealt with the issue of the covert recording. The Employment Tribunal, when awarding compensation to Mrs. Stockman, had only reduced it by 10% because of the covert recording. The rationale had been that the claimant hadn't been making the recording for the purposes of entrapping her managers into saying something unfortunate. She had said that she had concerns about what the nature of the meeting would be and felt the best thing to do was to record it so that she had a record of that meeting. The employer, on the other hand, said that the covert recording was a breach of mutual trust and confidence. In the circumstances, they would have dismissed her as soon as they found out about it, and so her compensation should have been reduced to zero. When looking at this point, the EAT disagreed, and they made some interesting comments here about covert recordings. In particular, that in the past, their view was that covert recordings were much harder to undertake. Therefore, it was more likely that they were being obtained for inappropriate purposes. However, given that most of us now have a smartphone, recording is much easier for someone to carry out. It was no longer necessarily the case, according to the EAT, that recordings were being done for an improper purpose. They agreed that it would be good practice to tell parties that a meeting is going to be recorded, but declined to say that it was necessarily the case that making a covert recording breached the duty of mutual trust and confidence. the employee might have legitimate concerns, as was the case here. There might be a dispute of the account of what happened at the meeting. Equally, the employee might want to take subsequent legal advice, and the record of the meeting would enable that to happen. These are all potentially appropriate reasons for recording the meeting. In short, the EAT decided that the tribunal had come to a decision it was entitled to come to, and therefore it did not interfere with a relatively minor reduction for the employee's covert recording. Now, given the outcome of this case, I think it has caused some concern for employers, particularly given the comments from the EAT as to recordings of meetings becoming more commonplace with advances of technology. I think there are some questions and practical points that employers might want to consider in light of this decision. First of all, it's worth, I think, reviewing your attitude to openly recording meetings generally. If an employee would be permitted to have someone present taking notes from the meeting, is it really so different to have an employee openly recording the meeting, or perhaps even the employer arranging for the meeting to be recorded? Of course, that has to be balanced against the concern that people might feel that recording a meeting will somehow inhibit discussion, but it's worth thinking about, we think. Secondly, is it worth adding covert recordings to the list of potential gross misconduct in your contracts or handbooks? The EAT commented here that it was unusual to see covertly recorded meetings as being on the list of gross misconduct offences in a contract or handbook. However, and just by way of reminder, if something is included in the list of potential gross misconduct offences, it doesn't mean that it necessarily is gross misconduct. A tribunal can still take a view as to whether or not a reasonable employer would have dismissed for such a matter, whether or not it was on the list or not. And finally, we have certainly advised on cases which have been slightly different fact pattern here, where there's been a concern that employees were trying to record meetings covertly in circumstances where it would not have been appropriate. For example, the employee might have tried to record a discussion between the employer when the employee had left the room, but the employer was still in the room discussing the aftermath of the meeting. I think if in that scenario it's sensible practice where the employer and employee have a meeting and the employer decides to stay on and discuss amongst itself what has happened, for that subsequent discussion to take place in an entirely different room to avoid getting into the difficulties that covert recording in that scenario might lead to. So that's the case of Phoenix House and Stockman, and now I'm going to hand over to Chris, who's going to tell us what the future looks like.
Okay, thanks, Miriam. Putting my Mystic Meg hat on, I can't remember if she wore a hat or not, but to finish off, we did want to flag some cases and legislation that is still to come, whether it's in the next 12 months or possibly a little longer. First of all, 3 cases that are worth looking out for. First of which I'm sure you'll be familiar with, Asda and Brearley, which is the very long-running equal pay claim. Female store staff claiming equal value against male distribution centre staff. The point that is going up to the Supreme Court is only an interim point, is whether or not the 2 groups of people can be compared with each other under the equal pay legislation, whether they are on common terms or not. So Asda is going for its 4th shot on trying to make that point successful. So we will wait and see whether they do. That should come on, we think, sometime later this year or early next. The second case, similarly, going for a 4th time and last time to the Supreme Court, is the Uber worker status case. These are the Uber drivers claiming worker status rather than self-employed status, and that one does have a hearing date in July this year before the Supreme Court. And I think Uber may be taking some encouragement from the dissenting judgment when it was before the Court of Appeal. Lord Justice Underhill gave quite a convincing argument for why the Uber workers should be viewed as self-employed and why the court shouldn't try to look behind the documentation that Uber has put in place in relation to them. it wasn't a sham, and so the Court of Appeal said it should be left alone. They should be treated as self-employed. We'll see what the Supreme Court has to say in July. And thirdly, Dronsfield and the University of Reading. This one is where the university is looking for permission to appeal to the Court of Appeal. This was an interesting case around what is the appropriate scope for an investigation report in a disciplinary process. Could an investigator give a view on outcomes? Could they make recommendations, or did they have to just stick purely to the facts? And whether or not they did one or other of those things, how much does that affect the fairness of the subsequent dismissal? Also, what is the role of HR and in-house legal in a disciplinary process like that? How much input can they permissibly have into a draft investigation report before it goes to the line manager for their decision? So that's an interesting case, certainly for HR and in-house legal, if it does go before the Court of Appeal. On legislation, as Miriam mentioned earlier on in the webinar, IR35, I think probably until recently was the most anticipated employment law development this year, probably not anymore. This was, of course, the tax rule change for employers who are engaging people through intermediaries such as personal service companies, and the huge shift in the burden for that liability and that risk really being put upon end user clients rather than the intermediary company. That was postponed because of the COVID-19 pandemic to April next year. There's, in the interim, been a huge criticism of the proposed new legislation, not least by the House of Lords, who've published quite a damning report. But despite that, the government is proceeding regardless, and in the last few days, it's appeared as part of the finance bill. And so at the moment, it looks like the changes are still going to come into effect in April next year. And finally, two other things just on the horizon still. Changes potentially to discrimination law, or at least so far as concerns sexual harassment claims. The government consulted last year on changes to workplace harassment laws. This is something come out of the general Me Too inquiry that's been going on for the last couple of years. Changes such as the introduction of third-party harassment provisions, extending time limits for harassment claims to be brought in the tribunal from 3 months to 6 months, and certain other changes as well. The consultation ended in October last year, and the government response to it was due in the spring of this year. We haven't seen that yet. Apparently the government has got other things on its mind at the moment, so we'll wait and see when that comes. And lastly, the new employment bill that was announced in the Queen's speech in December last year. This bill is said to put forward some things that the government had trailed previously, and those include a statutory right for 0 hours workers to request a more stable and predictable employment contract after they've been engaged for 26 weeks. An enhanced enhanced protection in terms of redundancy rights for pregnant employees, extending the protection they already have during the maternity leave period, so that their redundancy protection begins from the moment they notify the employer that they are pregnant, whether that's in writing or orally, and it continues after the end of maternity leave for a period of 6 months. So quite a significant extension proposed there. And lastly, a general provision that flexible working should become the default for all employees unless the employer has good reason to refuse. And I think in the current climate, where most of us probably are still working remotely, that may be an interesting one indeed. But on this, the draft bill is awaited, and who knows whether or not that will be delayed with everything that's happened since December last year. Thanks, everyone. So that brings us to the end of our webinar, but we've just got time for a few questions. If people have got time to answer them, please do. We've had a couple in already. We've got about sort of 8 or 9 minutes to try and stick within the hour. Miriam, I think you've had a couple I know that are on your section, so if I could just ask you perhaps to run through those.
Sure. So, hi everyone. So my questions on section 1 that have come through. First question, what is the sanction if you do not comply with section 1? Well, the financial sanctions are fairly limited. An employee can only get compensation from the tribunal of between 2 to 4 weeks' pay, but only if they're successful with another claim, such as unfair dismissal, discrimination, or an unlawful deductions claim. It's also worth bearing in mind that a week's pay is capped for these purposes, so it will be the same level used for statutory redundancy pay purposes, so currently £538. There's no standalone right to compensation without the underlying successful claim. So financial sanctions are limited, but obviously reputationally it's something you'll want to get right. And the second question I received about section 1 was, what does the end user have to provide a section 1 statement to an agency worker? Good question. The responsibility for providing a section 1 statement to an agency worker would be that of the employment business that engages them, as opposed to the end user to whom they're provided. Chris, I see you've got some questions on your section 2, so I'll pass over to you.
Yeah, sure. So just a couple of quick ones on mine that have come in. One on the case I talked about, Alan and Dodd, about recruiting employees with restrictive covenants in their contracts and being possibly liable if they then breach them for inducing that breach. Question is, is it better not to ask whether employees have covenants in their contract, because then at least you can't be directly liable for inducement? I think our general advice on this is no. I don't think it is better not to ask. The leading case on inducement is, if you want to look at it, is a case called OBG and Allen. And there, the House of Lords said, if you make a conscious decision not to ask, then you are deemed to be aware of what's in that contract. So I think, certainly in most industries, financial services, where it's expected that a recruit would have covenants in their contract, I think if an employer, if you just simply didn't ask the question, I think you'd probably have what's known as blind eye knowledge. You would be deemed to know that there were covenants in there, so it wouldn't really do you any good. And obviously, in practice anyway, you're better off knowing, because what you don't want is, your employee merrily breaching covenants that are in their contract, because that will come back to impact you in some way, even if it's not an inducement to breach claim. And the other question I had was on the Australia case. A few cases on the Australia case. May not have time to deal with them all, but one on the Australia case, which is the case that talks about positive changes being void before the transfer. The question, does that equally apply if the transferee makes positive changes after the transfer? And yes, I think it would. I mean, the Regulation 4 provision applies equally to pre-transfer and post-transfer variations. Obviously, and that is a lot of, probably practically where this case is possibly going to be more relevant. Quite often, when you inherit people on a TUPE transfer, you make a series of changes. Some of them are negative, some of them are positive, and you hope that in the round the employees will accept them, because overall the package is about the same. The concern has always been that, strictly speaking, if the negative changes are void, the employee could cherry pick later on down the line and say, well, yes, I take all those changes actually that were positive, I'll take those, but I don't accept the negative ones. And that was always the concern, that actually, based on the UK case law, that was what an employee could do, but and based on the government guidance. But the Australia case would suggest that at least that puts the employers in a slightly better position now, I think, and able to say, well, if an employee tried to run that line, then there would be the argument to say that, you know, both the positive changes and the negative changes avoid. But really, I think the practical answer is, if you're making changes like that, to try, if you can distinguish them from the transfer itself, if you can distance them in some way, either in time and link them to some other event, whether it's a pay review or a bonus round, then again, you might have the argument that those changes are connected to the transfer, but they won't be by reason of it. So you stand a better chance of getting those changes through, and that will be particularly important where those changes include important negative changes, like, you know, the classic one being post-termination restrictions, perhaps, that you're inserting into an employee's contract after a TUPE transfer. Perhaps in consideration for an increase in pay or bonus. The concern always is, can the employee take that bonus but reject the covenants later on? And that's always been a concern. So I think Australia gives you that argument to distinguish the reason for why those changes are being made. One final one very quickly before I finish off on the ISS case. The question was, if I'm a transferee, I'm inheriting 15% of an employee. I don't really want or need 15% of an employee. I don't have a part-time role for that person. Automatically liable for unfair dismissal because it's a TUPE-related dismissal? Hopefully not. I think you would be able to run an argument to say that if you didn't have a part-time role like that, that you'd have a redundancy reason or an ETO, economic, technical, or organizational reason for that dismissal. So it wouldn't hopefully be unfair, but you've still got the issue that it is your liability. It is technically transferring across, and you have that liability on the basis of this surprising ISS decision to make 15% of that employee's job redundant, which seems a very strange outcome to me and lots of other people, I think. But there we are. I'm conscious we're coming up to time, so I'll leave it there. There are a couple of other questions we may not have had time to answer, but I will follow up. We'll make sure we follow up with anyone who's asked a question that we haven't answered. And come back to you. One of the questions I can answer very easily, which is, will we receive a recording of this call? Yes, you will. We'll send that out shortly with the materials. And as I mentioned, I hope you've been impressed, if not with what we have covered, but with what we haven't covered. We have, I think, avoided talking about COVID-19 for best part of an hour, which is probably the first time I've done that in the last 3 months. But you'll be pleased to know that as a firm, we are producing quite a lot of material on COVID-19. There is a portal on our website, if you'd like to visit that, which has all of our content in one place. And when we send the materials for this webinar, we will also include the COVID-19 details. So don't worry, if you need to get back to COVID-19, then there is material there for you to have a look at too. That's the end of our webinar today. Thank you very much for joining. If you didn't have time to ask a question, please do email any one of the speakers on the webinar today. I'll be delighted to follow up with you afterwards to answer any questions on what we covered or what we didn't cover. If there's something we didn't cover that you've got a question on, please do let us know. Thanks very much. Stay safe, everyone, and hopefully speak to you soon. Bye for now.